Right, so good morning, everybody. Just before we start, my name is Iluezi-Ogbaudu, and I am the Interim Coordinator and Secretary of the Justice Reform Project. I am the team lead on this project, and I have worked hand in hand with all counsel and my Lord Justice present to make this happen. The JRP has, for weeks and months, pursued the introduction of remote hearings into our judicial system as a way to ensure the continued administration of justice during the COVID-19 pandemic and even to improve efficiency thereafter. What we intend to do today is to show you public how exactly this can happen beyond pushing for the passing of practice directions and reforms and adoption by the entities. We also want to show how this is practicable and how this can work. So we are not oblivious of the difficulties, the uncertainties, and all the problems that we may face. There will be erratic problems, there will be network challenges, there will be a little problem with the sound with the video, but we're trying as much as possible to make sure this happens. We will note the problems and continue to improve, and everything that happens here will become the basis for recommendations to courts across the country as we progress with this initiative, and as we ensure public safety and improve efficiency of the justice system going forward. On this note, I'd like to welcome you again. Thank you for joining us. I will then wear my registrar hat. I'll be a registrar for today, and I will call the case. Very quick. Suit number LD RH 001 2020. Raspotech Nigeria Limited versus Hesper Nigeria Limited. The Lordship parties are absent.
If it pleases your Lordship, Chima is my name. Chima Umezurike is my name, and I appear for the claimant respondent. And appearing with me are my learned friends.
Hello, Mr. Chima, can you do me the favor of spelling your surname, please? Just your surname.
It's spelled UME ZU
UMB
RUIKE. And appearing with me are my learned friends, Ifoma Sholanke Esquire, Oluyemi Adebo Esquire, and Kudus Adeyo Esquire.
Yes, my lord.
Very well. Thank you. Thank you. Yes, who appears for the...
It is your Lordship. I, Ademola Akinrele, appears for the defendant applicant, and appearing with me are my learned senior advocate, Mr. Sheni Adio, Mr. Nonso Anyansi, and Mr. Michael Wosu.
Hello, Leonard Still, can you spell the surname of the last person you are?
That's NWOSU, Wosu.
Very well, thank you.
Prior to proceeding, my lord, I just wish to make two observations in the meaning. The first is whether we can have your indulgence to allow us to sit down during the hearing of these proceedings. And the second is because, having regard to the nature of the application and the briefs, I believe that the reply and the main application overlap and run into each other. So I may effectively amalgamate my arguments as I proceed, which may obviate the necessity for actually arguing a reply. And if that is the position, whether the time that has been allocated for the reply could be applied whilst I'm proceeding with the main application. So I really trying to avoid having to reply, having regard to the very narrow issues, which I think I will deal with comprehensively on my side and might be more time efficient. And I hope I do not even necessarily have to use the 10 minutes and the 5 minutes there, but if I have to go beyond the 10 minutes, because the reply would be effectively amalgamated in the course of my argument, I would ask for the indulgence of your lordship to permit me accordingly. Those are my two requests.
Very well.
Thank you.
Mr. Umezurike, you agree to sit during the proceedings? That's fine with the court, if that is okay with you.
I'm very grateful, my lord. I'm very grateful.
Yeah. So we'll sit, it's a case management conference, we'll sit during the proceedings. And yes, if Leonard Silk, Mr. Akinrele will take 15 minutes for your whole argument. Is that fine with you? Then you wouldn't need to reply? Or you want 20?
It is, my lord. I just require 10 minutes to respond to him.
Very well. So, Leonard Silk, will you be taking 15 or 20 minutes?
No, I won't take more than 15 minutes.
You say it's in one
I'm hoping I can take
15 minutes
and 5 in one go. But if I don't exhaust the 15 minutes, and of course I may have, if there's anything substantial said in reply, I'll have something to say, in which case it may not be more than 1 or 2 minutes. But I'm hoping I can condense my argument within 10 minutes. So just to give me the liberty, just in case.
Okay, so we'll take it this way. You'll take 10 minutes and then another 3 minutes if you find it necessary, after your NFL has taken his own. Very well.
Yes.
Very well. So we start now.
Yes, the application, which is already, just for the sake of good order, you have an application dated the 30th of April, 2020. You also have written addresses dated the same day by the applicant, and a reply brief dated the 11th of May, 2020. The motion is clearly brought under Order 5 of the High Court Civil Procedural Rules and 43, and also Section 4 and 5 of the Arbitration and Conciliation Act. And we're seeking for 2 prayers. One is to have the action struck out on jurisdictional grounds. And the basis of that jurisdictional ground is that they have not complied with the conditions precedent to the action. The second ground, of course, is to have the matter stayed pending reference to arbitration, which is an alternative ground. And I use the word advisedly because I will make a point on that when I get to the second point. With regard to the first point, I think we're all agreed that conditions precedent to the exercise of the court's jurisdiction must always be complied with. The difference between the parties is a narrow issue of whether they have complied with the pre-action protocol. It is our contention that this court should look at it from the philosophy which is contained in the preamble to the pre-action protocol, Section 3, that says that it is important that parties in pre-trial correspondence must understand the case of each party, because that is vital to having value to the settlement. If you can achieve it, that will prevent the courts being clogged. It is our contention that even though the claimant appears to have a series of correspondence where it has indicated its case to us, vital and central elements of their case, which we only came to know about at the time when they filed the action, was missing in that correspondence. And I would like to point out the fact that this is a claim-specific action, which is for recovery of debts. And there's a specific protocol for it, which indicates, and we refer to that in our reply brief at page 2, where you must state the claim, state the interest, and any other particulars. It is extremely particular so that we have no doubt at all as to the scope of the claim. Now, this is not just a cosmetic or technical or superficial issue where we are saying because you do not follow a particular format, therefore you haven't complied, which would seem to be the case of the claimant, because they have indicated generally their case through a series of correspondence. It is a substantial issue, and the reason why it is substantial is because there was introduced a claim for interest of 15%, which on a claim for 15 billion, you can imagine that is about, in a year, is about 7.5 billion. And in half a year, which is from when the cause of action arose in January up till date in June, that's about 3.75 billion. And then there's a claim for damages of 1 billion. And neither of these issues were raised in any of the correspondences. It is a notorious fact that in the course of settlement, when parties sit down in a commercial transaction, whether in a creditor-debtor situation, whether in the form of a financial institution or in the form of a company, where interest is of a substantial nature, negotiation may have gone on where the party decides, perhaps I should settle the principal and leave the interest. But all of a sudden, we are faced, at the time when we receive the papers, that there is a substantial claim of interest and a substantial claim for damages. And to the extent that those aspects were missing in the letter of claim before us and in all the correspondences, I will be submitting that there has been a breach, and a real breach, not a technical breach, of the pre-protocol rules. Because it could have made the difference to whether we are before your lordship today or whether we would have settled the case. The second aspect of that submission, of course, is what is the consequence if that breach occurs? Our submission is that it nullifies the action. It's not a question that can be remedied by the court directing we go back or any other remedy. And that is the difference between the 2019 rules and the 2012 rules. In 2012 rules, you could cure possibly through irregularity, or the registrar may refuse to accept things for filing. But under these rules, it says it quite clearly in Order 5, and even in Order 7, it reinforces it, it nullifies the action. And the severity of that remedy is an illustration of the fact that the philosophy towards settlement is very, very important, and our parties must understand entirely what they are going to face and have a genuine opportunity to resolve it. And therefore, I would be asking this court to have the matter struck out or dismissed for lack of compliance, which is a condition precedent to the jurisdiction of this court. I will proceed, my lord, to the second issue, which is the issue of stay of proceedings pending reference to arbitration. I want to start from the premise that the presumption and the principle is that a court must always encourage arbitration and only depart from it in circumstances that are very, very clear. It is quite clear that we filed this application timeously 2 days after we received the statement of claim. On the 30th of April, we received the statement of claim on the 28th. On the 30th of April, we filed the application. We averred in the application that we are ready to proceed to arbitration. The issue between the parties, the very narrow issue, is that we filed a defense. And under the section 5, I'm sorry.
Just a minute. Yes. You alluded to your statement of defense.
Yeah, yes, I alluded to the fact that we
particular paragraph.
No, the point I'm trying to make is that the statement of defense filed generally in this action as a document. And they have taken, I'm sorry, I'm
listening to the question. Yes, please listen to the question. The question is, you alluded to a pleading in your defense that you're willing to go into arbitration.
No, that's in our
what paragraph?
That's paragraph 9.
Okay, so it's in your Very well. So it's in your affidavit, it's not in your statement.
Yes. Yes, it's an affidavit that we indicated that we're willing to go to arbitration. The point I'm trying to make about the statement of defense is because their answer to our application is that we filed a defense and that under Section 5 of the Arbitration Act, we have taken a step. And that's a narrow issue for to determine. And my answer to that issue is you need to look at that issue in the context of the application before your lordship. The application before your lordship has a primary application to strike out a matter for jurisdiction, and then an alternative prayer to stay. Demurrer has been abolished in Lagos State under the current rules, Order 24. And therefore, we are compelled, for the purpose of raising an issue of jurisdiction, to raise it in the pleadings. Now, my argument is, if we have done so for the purposes of taking an application for jurisdiction, that cannot be translated to the fact that we have taken a step. And I say this in the context of waiver supposes an intentional and conscious act. If the set of rules compels you to file a defense by operation of law, and you have done that in the context of your case, to take the point that this court has no jurisdiction, because we cannot get to the point of stay if we see a jurisdictional issue. In fact, we are duty bound to raise a jurisdictional issue before your lordship. And in raising that issue, the law says, file a defense. You cannot exercise a discretion for stay if you have no power, because the law on stay pending arbitration assumes the court always has jurisdiction. Then in the exercise of discretion, you determine whether or not to refer it. So when counsel has taken the point that there's an issue of jurisdiction as a primary relief and has had to file a defense, how can one genuinely say that he has waived his rights to proceed to arbitration? It will become a total aberration for a process to be valid. And as counsel, you have a duty, if you see a jurisdictional point, to raise it first. So I wish to make the point, therefore, that the underlying issue, which has been the central point in the case of the claimant as to why we should not be able to go to arbitration, which is the filing of the defense, is actually been misconceived. Because for the purpose of the application for stay, all we are interested in is the contract, which we exhibited in our affidavit at paragraph 6. We're not relying on the fact that because we filed a defense, the defense was filed for the purpose of the application on jurisdiction. As regards the application for stay, all we are relying on is the contract, Exhibit A, which, if you look at our affidavit, we put it there. So that is why, if you look at all the cases where this point has been taken, your lordship will find that it's usually in cases where there's no other prayer, where the real prayer is just for stay, and then you file a defense. But in this case, that is not the position. There is another prayer, which goes to the source of the lordship's power, and that requires us by law that we must file a defense. To conclude, there's a decision which we refer to in our reply brief, which is very instructive, Chevron and USA Britannia. Chevron and USA Britannia referred to in our reply brief, which I think supports very clearly, and was exactly what occurred, even though it was an arbitrary decision in the Federal High Court. They took an issue of jurisdiction, prayer 1, and prayer 2 referred the matter to arbitration. So counsel took the view, because you have filed a defense for purposes of raising the issue of jurisdiction, you have waived your rights on the issue of arbitration. And the court says, no. You cannot, in those circumstances, be said to have waived your rights. That has been covered in our brief. And therefore, I argue that if we fail on the primary prayer of the action being struck out, then I will urge very respectfully that the lordship has the power and should refer the matter to arbitration. And our non-filing of the defense is totally immaterial in the context of the specific dual prayers that are before the lordship. I'm most obliged.
Thank you very much for keeping to time.
My Lord, in opposition to the defendant's motion of notice, the claimant filed a counter affidavit that was deposed to one Tolani Adeoye on the 6th of May, 2020. It contains 13 paragraphs. In addition to that, the claimant also filed a written address dated 5th May 2020. And I will respectfully adopt the contents of that written address as the claimant's submission to the position to the motion. Then I'll make a very few brief points in response to the defendant's application. The first ground for saying that the claimant's claim should be struck out or dismissed is on the ground that it's a nullity. And in reliance on that application or that argument, the defendant relies on Order 5-13 of the High Court of Lagos State Civil Procedure Rules 2019. And if I may refer your lordship to that rule, it says, Order 5-13, failure to comply with sub-rule 2 above shall nullify the action. And sub-rule 2 says that all civil proceedings commenced by writ of summons shall be accompanied by a list and copies of the following documents. A is not relevant, B is not relevant, C is not relevant, D is not. Then it's E that is relevant. And E says is a pre-action protocol form 01 with necessary documents. The claimant in this case filed a pre-action protocol form 1 with necessary documents. And unless the defendant can point out a particular necessary document that was not attached to the form 1, then his argument on this point fails completely. The second ground for the defendant to contend that the claim should be struck out is for an alleged failure to comply with the pre-action protocol for recovery of debts that is contained in the practice direction number 2 of 2019. And can I refer your lordship to page 21 of that practice direction that deals with the recovery of debt? The alleged defects or non-compliance with this protocol are twofold. First is that the claimant refused or failed to include a relevant document, which is a contract giving rise to the debt. My response to that is this, that the defendant did not request a copy. And in any event, the defendant always has a copy, has always had a copy of this document, and also relies upon it as one of the documents he tends to rely upon at the time of this action.
I'm not quite sure. The argument is that you did not include documents that showed that you would be claiming for interest and damages, if I understand the argument properly.
I'll get to that, my lord. I'll get to that. I don't think in relation to the debt, the debt is the cause of action that arises from the defendant's breach of contract. Then the damages that are being claimed by the claimant is ancillary to that breach. And in my submission, should not be contained in the pre-action protocol because for the recovery of debts and damages is quite different from the debt. The debt is the $50 billion Naira that arises from the contract between the parties. And if I may refer your lordship to page 22 of the practice direction, where it says that the claimant, the creditor should also do one of the following. It's paragraph 1.2, then Roman figure 3. It says, where no statements have been provided for the debt, state in the letter of claim the amount of interest incurred and any administrative or other charges imposed since the debt was incurred. The claimant does not claim interest prior to the action being commenced, and therefore was not required to include interest. The interest he claims is from the commencement of proceedings, not pre-action. Then secondly, since the claimant is not claiming any administrative or other charges, is therefore not required to include that in the letter of claim. And in any event, my lord, the sanction for not complying with the pre-action protocol is not that the claim should be struck out. Can I refer your lordship to the relevant part of the Practice Direction number 2 of 2019 is on page 3 and page 7, paragraph 1, that says that where a party has not complied with the provisions of this protocol, then on the next page it says the following sanctions will apply. A is that the originating processes with supporting documents shall be accepted for filing at the registry. B, C, D, and E do not apply. In this case, since the registry accepted the claimant's originating process and supporting documents is deemed to have been complied with, and therefore it cannot be struck out. Then in relation to the argument or the submission that this claim should be stayed pending arbitration, the defendant in its written address then relies on the UNCITRAL model law 2005 revision, which gives the court a discretion to stay proceedings even when the defendant has delivered a defense. And in my submission, that treaty has no force of law in Nigeria. The appropriate law is section 5.1 of the Arbitration and Conciliation Act, which makes it very clear that once the defendant has filed a defense, it cannot then apply for a stay of proceedings. If the defendant is contending that the court does not have jurisdiction to entertain the claim, what it should do will be to enter an appearance first, which will be conditional, and then apply by motion or notice to have the case struck out on the ground that the court does not have jurisdiction to entertain the claim. What it should not do is to file a defense in response to the claim. Having done that, is then debarred from applying for a stay of these proceedings. My Lord, I cannot put my case any higher than this, unless I can be further further assistance to your Lordship. Those are my submissions in this case. Thank you, my Lord.
Thank you very much. I really appreciate Counsel for keeping to time, and you have even used less time, so this is really good. I appreciate that.
I'm very grateful, my Lord.
Leonard Silk, do you have any last words for us? Mr. Akinrele.
Leonard, Counsel for the claimant. Can you hear me? Is it on? Can you hear me, my? Yes.
Yes, I can.
Yeah, just make a statement for a few seconds. He made reference to regarding the issue of interest, which I made very heavy weather on. That was missing in their claim. That was not a claim they had till they got to court. But when you read their statement of claim in their order, it says to pay the claimant interest on the said sum at the rate of 15% per annum until judgment, and then after judgment, 10% per annum. It is a notorious fact that when you make a claim for interest prior to judgment, it usually arises from when the cause of action arises. So to come up with the argument at the very late stage that our claim for interest is all of a sudden arising from the claim is a means to avoid the very reason why you have to, in an issue of debt, to have made reference to what you were saying or what your position was with regard to interest. And I still maintain that that is fatal in terms of, particularly with regard to its quantum in respect of their non-compliance. That's all I have to say. And I'm most obliged.
I've read all the processes and I'm able to deliver my ruling, but I need a few minutes to consider more of what the addresses have, the issues that have arisen from your oral address. So the court will go on recess and reconvene in the next 10 minutes. It should take us to 5 minutes to 11. Is that understood? Can you all hear me? Learning
Yes,
Counsel,
yes, my Lord.
I can hear you, my Lord. As the call pleases.
So we'll convene at 5 minutes to 11.
All right,
call pleases.
Court rise. 5 minutes to 11.